think we're just getting online here. If we are live, I see Ocean Sounds. I see Detective Wobbuffet. I see Kelly. I see A to B rocking the early chat. I think that's our crew of early birds. Early birds, I'm going to give you a little treat. We've got a Cadillac sighting. Good morning, Cadillac. We won't even start the streamer until, or the 5-minute countdown until I put you down. Anything to say to the people? No? Looking good, though. Looking good. Okay, we'll put you down. We'll put you down. We'll give you a little snack, too. You get something for showing up on camera. Cat has a better union than the dog. Gets paid for each appearance in Temptations. There you go. All right. Let's start the 5 minutes. The 5-minute widget and begin. All right. That's a short countdown. That's just enough time for me to roll a little medical cigarette to get the day started. If anyone's on the replay crew, you're certainly welcome to skip ahead 5 minutes to get straight into the Sarah Boone coverage for today. But if you want to stick around and enjoy all the welcome and fun and chaos that is the 5 minutes before the show, I mean, that's your prerogative as well. 4 minutes and 33 seconds remaining. Little housekeeping. I think it's in my opening show notes, but there won't be a Friday Night Ramble tonight or next week. Tonight, it's because after today's show, Canada is playing in their first World Cup game of the tournament, and it could well be Canada's first ever World Cup victory. We've made it to the World Cup many times, but never won a game within it, so that would be exciting. So I'm going to watch that. And then the USA is taking on Paraguay in following that game. So I'm going to be locked in on World Cup today after the show. What I may do, and don't count on this, it's not really topic related, but I may show up in the evening for just a loose chat, just a vertical live hangout. Chat with each other, enjoy each other's company, no show, no graphics, no nothing, just my voice. Occasionally I'll flash my face up on screen to show that I didn't pre-record it. But, I guess it's pretty obvious if you're interacting with the chat, it's not pre-recorded. Either that or that I have a crystal ball. Maybe I do. Maybe I do. Enough of that. 3 minutes to go. Let's get this rolled up. Anyone get to hang out in Suma's live last night? That was a lot of fun. She got to show Chelsey and Haley, the same sisters we got to watch on the random body cams last week. If you missed out, the Let's Play live stream had us starting off by playing the Let's Play Sarah Boone Chutes and Ladders clone, Motions and Demotions. And we followed that up with a very highbrow watch of the Florida 6th District Court of Appeals, tearing apart a lawyer's appeal argument for, and I quote, "You realize your argument has no argument in the argument section, sir." So that was a fun and kind of, erudite listen. It gives us a little bit of insight on what Sarah's appeal can expect, because it was the 6th District Court, and they're not messing around. Panel of 3 judges that, they say stuff like, "Sir, that's not a thing. It's not a thing, sir." So that was fun. And then we followed that up with a little lowbrow to finish the evening, and that was Haley and Chelsey initially mad at the police, but fairly quickly as mad at each other as they were the police. Chelsey has a special talent for, well, both financial planning and roasting her sister. Very low-key digs that landed. So anyway, that was a lot of fun. Shout out to Summa Cum Loudmouth. Watch her Friday live streams to get a part of all of that fun. And here we are, 55 minutes away from this one. I'll save this until we start the show. Let's just quickly go through my transitions before this goes live. All right. Oh, that's, yeah. We want that to be on the screen, so that's a good find. Okay, there we go. That'll be that. And back to here. In zoom mode, that's that. Okay. Yeah, that's a little bit more, I think there's some kintsugi I've got to this layout today. Let me know what you think. I'm trying something a little different with that one. That's the main me. I have changed it, so if it looks like I'm looking down, it's because that's where my laptop is. I've got the camera up here. It might remind me to actually look into the camera instead of at my screen when I'm talking to you. We'll see if it works. We will see. Anyway, that says there's no time remaining, so we should launch it. Maybe we'll launch to me. All right. So then we also need to launch that. And boom. Okay. All right. Welcome to the show. Good morning. Today's agenda, we have a commentary and rewatch party for 4 hours of raw Sarah Boone trial footage from 2024. We're going to be starting with Sarah taking the stand. We will hear her Miranda arguments. We will hear motions for hair, cosmetics, and clothing. What we will not hear is any remorse or anything resembling a strong defense. Good morning, fine and dandies. I hope you're feeling fine. I'm Dan D. Let's get right into it. No, maybe not right into it. Let's get back to be a little social, but we'll get set up. We'll get set up and see if anyone else has joined since the hellos. That's not the screen I want. Oh, things have gone sideways quick. If that's not the screen I want, then where is the screen I want? That's it. Another one to say has made it. Candace is here. Disney Mom. Paul Clink in NYC. Tennessee, Paul Clink in NYC. Beth of a Salesman. What's up, Beth? Fuck you. Good to see you. All eyes up here. Okay, yeah, show's up here. Down there. All right. Rita Schuler. I haven't seen you in the chat for a little while. Glad to see you back. All right. Kelly dipped on the sisters. Couldn't go through it again. Oh, I double dosed. I saw things that second time that, well, there was a lot of it showing the first time too that said they weren't the most demure young women, but in any case, we're not watching the sisters today. We're watching Sarah Boone. We're going classic. We're going vintage. We're going old school. We're going back to 2024. So you saw the rap songs I used to listen to. This is 1999, motherfucker. Everything that was in the 19s, they were angry. Very angry. I am stealing that bit from a comedian. I can't remember the comedian, but if anyone heard it, they'll probably remember the bit. I don't know what they were angry about in the 90s. It was 1990 motherfucking 3. Word up. Okay, let's, I think we've done enough swearing to start the stream. Let's just start the show. We are going to go back a little bit. So where we left off the last hearing, Chelsey Koepsell was on the stand, so we will return to just a little of her testimony to get our bearings. She testifies for about 10 more minutes in this section of the video. This is James Owens just looking for anything that might stick to the wall. Threw a bunch of spaghetti at the wall, and maybe there's a piece that's going to stick for this Miranda argument. Spoiler alert, there is not. But that's where we're going to start. There'll be a brief argument about the merits of the Miranda arguments, and then Sarah Boone takes the stand. The main point of Sarah taking the stand here in the motions hearing is that James Owens needs to get an overt act into the evidence in order to use a battered spouse defense. At this point, he has not. He wants to argue in his opening arguments that Sarah's a battered spouse. Judge Kraynick has agreed with the state's argument that that's an affirmative defense. He needs to prove it first, and he can't bring it up in his opening statements if there's no evidence. So I think that's the purpose of Sarah taking the stand. Another spoiler, Sarah does not establish the overt act, and that's why we have a second. Well, if you guys seen the trial before, you know that there's a whole separate mini hearing within the trial about the discussion of an overt act, but this is the first attempt. All right, Chelsey, take it away.
Same objection for the record.
Overruled.
Yes.
Oh, one other thing. It took me about half a second to get my first pause in. I made audio adjustments. I rebuilt my whole show structure from top to bottom last night, including audio. When I was listening back, I noticed that my audio would sometimes, it wouldn't kick in as soon as I started talking. So I've tried to make some adjustments so that you're not missing the first word. I've also tried to make it deeper and more resonant, so when I'm speaking like this, so anyway, let me know if any of that's working for you. If there's anything that's off in the balance between the audio of the video we're watching and my audio, let me know. All complaints are welcomed. I don't do everything perfect. I'm not an outstanding mother to my children, so I don't take any offense to constructive criticism.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection. Relevance.
Sustained.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
Carolina?
Because of her inconsistencies.
Objection. Relevance.
Sustained.
That reminds me too. I think there's going to be an actual dropout, like a technical glitch. I'll fast forward through it instead of just watching it this time. But now that I remember this part of the testimony, I seem to remember that.
Now, you said you've had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
Phil Dom Russo says, "Where's the hole? I don't see a hole." Yeah, and if there was a hole, the damn hole didn't do him no good, did it?
2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed.
And Super Kelly G is quoting from the sidebars where James Owens complained to the court, and this is on the record. "Your Honor, he thinks he knows everything. This is my chance."
Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall?
The other thing to keep in mind is that the last hearing, James Owens said he wanted to discuss Miranda arguments, and James Owens said, "Well, I haven't seen the video, but I can watch it, I can review it, and then I'll be in a position to rule on these motions at the next hearing if I need to review that evidence." So Judge Kraynick knows everything now. If he's tried to, keep himself away from the discovery, "Miss Boone, I can't look at your discovery. We have to make a process. We tried to expedite it. We tried to do what we could to make it as fast as possible." But yeah, now there's no choice. He has to look at the interrogation to examine the Miranda argument, and by watching that interrogation, Judge Kraynick is a lot more aware of the particulars of this case than he was prior to this hearing.
You saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Okay.
Objection.
Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Send your healing vibes out to Detective Wilberfett, who's feeling a pain flare-up, and sorry in advance if she gets a little bitchy. So you came to the right place. You can probably be bitchy in the chat. We'll just take it as a, hey, good to see you. Just how we greet each other here.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Good call, Paul Clank, picking up that Sarah's sitting in a green chair that doesn't move. I think they made a special requisition for green chairs, 4 that move and 1 that does not, for the Sarah Boone hearing that will be taking in this courtroom. Yes, we need 1 green chair that doesn't move. Thank you.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection. Improper question.
Sustained.
Let me go back to the first question then.
James can't remember the first question that he had the overruled. He's like, I'll go back. You go back, James. You ask it again.
Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Improper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection. Relevance.
Sustained.
It's getting bright out that window, that's why.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting
Charles.
question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection. Relevance.
Overruled.
I did not ask her question number 9.
Okay.
I did not ask her question number 9. I like the way Chelsea's eyes are like, okay, you got what you wanted there. Charles Grieve reminds us, where did it go? Another inch off the back and Sarah would look just like the Normans on the Bayeux tapestry. It's a little like Ralph Wiggum.
Do they have a Miranda cards form in the
Why do I have a
interrogation room?
yellow box around my head?
So you would have had that on your person?
It's not intentional. It's not intentional. So what it is the sun is coming right through that window up there. Should probably do something. Now we'll just wait. We'll just sit through it. We'll get through. It'll go away. The sun moves. The sun stays still. We move. But we'll move. Yeah, that's the problem. It's picking up the window rather than me. I wonder, maybe I can change the focus. So I go back to that. Ack. Nope.
You may.
Oh, and apologies for the sound if it's quiet in the court. Whenever James Owens walks away from the mic, it's going to be like that.
This is our waivers and affidavits.
Is that filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
Okay. And is that form filled out as it relates to Sarah Boone?
So he's asked, is this filled out by you? Chelsey says, yes, I filled it out, but that highlighting's not me.
We're talking about just this top, right?
Yes.
Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature or not?
Yes.
Did you see her sign it?
Yes.
Is that your signature or not?
Yes.
Super Kelly G, I am working on it. This little area I'm in could be a studio. It's not yet.
The consent to search, yes.
On that form, is there also Miranda warnings?
Yes.
That is a form that's standardized.
So these are all questions
Yes.
about the form that James is asking if you can't hear him.
For those rights?
From this piece of paper,
Yes.
that's audio and video recorded, that, no.
Okay, you would agree that there's 9 questions on that form? Would you not?
Yes.
Margaret Adam. Hello, everybody from Scotland. Hello, Margaret.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Moldy gold, Phil for Rom.
Judge,
Dom Russo.
obviously, we disagree.
Well, then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas,
that's
Powell
so
from
savage.
the United States Supreme Court, which reversed a Florida Supreme Court decision.
Not only did Judge Kraynick look up all of the information and have his case law ready, the first case he cited was State versus Owens. Like, that's got to put you at a pause as a lawyer. Really? There's a State versus Owens? What did they say in State versus Owens, Your Honor? I'm a little embarrassed. I don't know.
From the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda, and that question number 9 response.
Judge, obviously, we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens,
Hey, Riley, welcome.
State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about
Door
what's required by Miranda,
2413.
and that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you.
Those are the questions. That's what's in the Constitution. Everything beyond that is over and above.
Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
But they were. And where James is going, like, if there's any credence to what he's saying, the credence is as a disciplinary thing. I'm looking at the screen. I got to start looking at my camera. That's why I set it up this way. It's a disciplinary thing, possibly within the department. Hey, you didn't read the card right. We give you these cards. We'd like you to read them word for word. You didn't read question 9. You know, spend 2 weeks cleaning the dishes in the staff room, or, you know, whatever slap on the wrist punishment you get for missing a policy. But that's pretty much the extent of where, you know, James's argument goes. As Judge Kraynick very eloquently pointed out, the Miranda constitutional protection talks about being properly informed of your rights, not about, you know, some arbitrary wording of 9 different questions that essentially do that. Asking 8, you can make a good argument that the person was aware of their rights.
I want to finish my argument.
Okay.
I want to finish
She
my
has a
argument. Oh, that's good too. So he tells, and we'll rewind just about 10 seconds there, but he tells the judge he wants to finish his argument. You can just see Judge Kraynick. Okay, you know, I'm already ruling against you, but if you got the words all packed up and need to come out, let them go.
You agree to speak to me now. That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. Jhaie?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue.
Such a simple argument for Mr. Jhaie. It's basically the defendant trying to invent new case law. Ooh, that's a great idea. You can invent new case law?
Of the decisions in Thomas 351, Southern 3rd 197, and Owens 41, Southern 3rd 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Just a quick reminder, switch it to all messages, just like I did not have it on my secondary chat device. If you're on all messages or live chat, you'll see all the messages from everybody in the chat, and you won't miss out on messages from Riley the Wonder Pup or Without Emphasis, who I see people referring to, but still can't find a chat from them. In any case, oh, there you are, Without Emphasis. Good morning, loving the 70s vibe. Thank you. Thank you. I'm feeling 70s. It's mostly because all my stuff's old. The broadcasting equipment's relatively new, but yeah, all this stuff, that's real. That's not a backdrop. These are all things. Welcome to the chat.
Do you agree, Detective, that after you read her those Miranda rights?
Okay, here's the dropout. Yeah. Won't get fooled again. We're skipping past that. 127.18. Yeah, I know what's happening.
Was different from the situation the day before when you read her Miranda in the squad car?
Video will improve just like the audio did, I believe.
That was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, I did, at the time of the interview, yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
I mean, I didn't tell her she was free to leave, but yeah, you're inside a car, like you're not just going to get out and go, but the thing that's ridiculous about this is the state, and I think they say this later, they're not arguing custody. They're not saying that this wasn't a custodial interview. So for Owens to spend any time belaboring the fact that, was Sarah free to leave? Sarah spent 8 hours sitting outside the property. Isn't it true she had to go to 4 neighbors before she was able to get a bathroom she could use? Had to go across the street. I heard Kim, she's not nice.
That's all the questions I have at this time.
Any redirect?
Nothing.
All right, can this witness be released?
I'd like her to stay.
All right, subject to recall. Thank you.
Hey, is it San Jose Sheila? SJC
State,
Sheila?
you may call your next witness.
In the
No
chat,
additional
welcome.
witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction of the court.
No, I don't object to the authenticity.
All right, Judge, I would
I
like to
still got it.
produce
What can we do about the lighting?
any more cases of exhibits.
The lighting got worse. Oh. Aha. That's a trick. If I get my head over closer to the mirror, the window. Let's see.
Just that one.
What is it that's been marked as Defense Exhibit B?
Judge, it's the,
Yeah, zoom in on that helmet. What is going on there? The recently trimmed topiary has gotten a little scraggly, a little ragged.
Any objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the... Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. Jhaie, I wasn't specific enough. Mr. Owens, to you. Any additional argument?
same argument I've made.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
It's a lot of upper body. I'm not sure I like this view. I have to sit up straight, have good posture if I'm doing this. Oh, and then it goes dark.
And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge, it's the policy of the Sheriff's Department. And it's a general
Okay, I think I have a solution. Gonna let this play. You'll see me working around here in the background. Talk amongst yourselves. I'll be right back.
Do you know what page specifically those policies are on?
Page 14 of 22. And I'm going to give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes?
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P. And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Anything else?
No other argument, Judge,
Okay.
other than what we talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence. Over objection is states 1. I'm sorry, defense is 1. Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium. She was previously sworn at the beginning.
There we go. Oh, it gives me a little halo.
Y'all be
even.
here.
I'm back.
Yes, sir.
And the light is
And the
shining.
deputy's got a mover.
Oh, we're perfect timing. Hang on, the deputy's got a mover. Shine, 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 oh, won't you let the light shine? All right, Sarah takes the stand for no good reason. Let's switch to a little bit more up close and personal.
Ma'am, you've already been sworn. Counselor, you may proceed.
Haha, you don't get to say 10-10-7-7.
And would
Biatch.
you please state your full name?
Sarah Boone.
You're going to have to speak
up
into
or
the
move
mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Where are you currently housed? I don't know what it is about the way he says that, but yeah, we're going right back. I don't know what it is.
Ma'am, you've already been sworn. Counselor, you may proceed.
Ma'am, would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase.
Oh, shit. Sorry.
You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
Deputy Kayla Rodriguez
What
was fantastic.
mental state did you have at that time?
I was very confused. It was very hazy.
Yep.
I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs.
I was worried about my son. I was in shock. I was traumatized by the situation, and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
Okay.
Again, I just love Judge Kraynick's tone there. Yes. I don't know what you thought I was ruling in regards to, but yes.
I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
Okay.
It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it.
Okay.
Objection sustained and it's stricken.
All right.
And this goes to the problem with going on the stand here in the pre-trial hearing. Sarah, for whatever reason, and maybe, the two of them together were like, James is like, oh, I can't do that because, I would need to establish this. Well, I can say that. Oh, it's not a good idea to put you on the stand in the pre-trial. Put me on the stand. I'll just say it, and then you don't have to ask me about it. I'll just find a way to work it in. And then once I work it in, then you can do your magic. It's like law's not magic.
Did you speak to the deputy about what had happened?
Yes.
Hey, Ann Janeski.
And then were you asked to stay on?
I was just going to say live to Ann, you don't have much to catch up on. Join us live and watch back because we're only probably about 5 minutes into new material. But maybe somebody in the chat could mention that to Angie and let her know. Skip ahead to about 5 minutes ago anyway.
Scene.
By both, yes. By both detectives, yes.
Okay, how long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it
Ramono.
was not quickly.
Welcome.
Did Detective,
Tammy Sellon?
the 2 detectives, when they
ESR?
arrived, did they take over the investigation?
It was my understanding, yes.
LTD?
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay.
Good
Can
point,
you
Ramono.
explain what the detectives...
Ramono coming straight into the chat with a little fire. Just noticed, Owens said the morning after you found George Torres. Not the afternoon. And if we remember correctly, it was Kayla Rodriguez. It's 1 in the afternoon, man. I know! Yeah. Owens said the morning you found George Torres, not the afternoon. You finally rolled out of bed in a room full of dog poo and urine. Welcome to the chat, Ramona. We're going to have a good time here.
told you as it relates to you getting in the car? Was the phone issue before the car?
Deb Richardson, welcome.
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that
good point,
Koepsell
Candace.
asked me was if I owned a phone.
What did you say?
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Objection calls for ceasefire.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
You told
If you can't hear the objections, most of the objections are based off of foundation. Sarah doesn't have any foundation to testify to police procedures. So whenever Owens asks, who got you your phone? She doesn't know. So she's not allowed to testify. She is allowed to testify as to how she felt, what she observed. So you notice he starts phrasing a lot more questions with, what were you told?
you that.
Detective Koepsell,
How did you unlock it?
she handed it to me and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay.
I did not.
After that incident,
Did you ever let him out of the suitcase? I did not. Did you ever see the phone again? I did not. The exact same tone, inflection, like absolutely no abhorrence about the suitcase whenever it's brought up. Like, even if it was a horrific accident, you'd think that you would just be repulsed by the sight of it, the memory of it. But she reacts to it exactly the same way she does about, not being able to have her cell phone. Like, that's an inconvenience.
was the next time you were spoken to by Detective Koepsell was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
All right. Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
So she's blowing it here. She's probably told Owens 100 times. They kept saying normal protocol. So he's asking her about it. Did anyone say protocol? No, not in the squad car. Not that I can recall. So even if that was their plan to go in here and say, she said protocol and made me think it was just something, I shouldn't really worry about it. She's blowing it here. And Owens is like frustrated. He's asked twice, trying to get her to get in on her complaints. This kind of, that kind of speaks to something too, maybe like as a hindsight notice with Sarah. She talks a big game until it's almost like a pro athlete that's not able to perform when it's a big game, or she talks a big game on the sidelines and then it comes time to perform. And, she's afraid to go in on the protocol. She's afraid to be full Sarah, like full evolved. She's this meek little, not that I can recall. I don't remember.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right.
Hey, Victoria, welcome.
Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
Will you ever own a phone again? I will not.
All right, after they
Good one,
finished
Candace.
interviewing you in the unmarked vehicle, were you allowed to get out?
Welcome,
Yes.
Mama Lola.
Were you allowed to leave the scene at that point?
I was instructed by those to not.
Okay. And how long did you stay on the scene?
A long time.
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay.
10
At
hours.
some
Hold
point,
on.
Did they
Hold
all
on.
leave?
10 hours or more. So it's 1 o'clock, ma'am, when they arrived. So you think they were there till 11 p.m. and she was still just sitting outside, sitting on Kim and Eli's stoop, waiting to be allowed back in the house? Because she didn't go back either, right? She went to Brian's. And then from Brian's, she goes to the interrogation the following day. So what the hell is she hanging out at her house the whole day for? Just to, oh, okay, I can go in? Okay, goodbye. Going down by Muldoon's. And then I'll hit Brian's after on the way.
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
So there, that's exactly what I just described in her stupid little Sarah voice. 143. But yeah, she says it was 10 hours of investigation, so that takes you to 11 p.m. If she was free to leave, why didn't she just leave before? Or she's told, well, even, it doesn't matter if she was free to leave or not. I'd think she would be detained. She'd be a person of interest anyway. She's still a person of interest.
Did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
Midnight. Brian, open the door. I got my shit. The Kia's parked outside. I need a place to sleep.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact...
Hold on, what was that too? So, were you going to spend the evening with your son and ex-husband? Yes. And did you do that? My son? Yes. What, did Brian sleep outside? Put him in a tent? 143.55.
about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Koepsell's private cell number?
She gave it to me before she left the scene.
Yeah, liar.
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
I was terrified of his family. If I was authentically terrified by his family, where would I go? Maybe to Son's place. Maybe where the one other person that I love in the world is. Maybe I'll bring all that smoke over there. She's so stupid.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son.
And that might have been the moment that Owens thought he did enough. That he got in, oh, well, she did say she was terrified of his family. Judge, that's enough, right? She said she was terrified of his family. Your Honor, I don't know what more I could do. Well, you could prove there was an overt act, Mr. Owens.
In with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Koepsell?
I did.
And whose phone did you use?
Former husband, Brian Boone.
Former
You said your
husband,
phone
Brian
had been
Boone.
seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Koepsell told me she or Lowen or both would return back to my apartment to return my phone
We'll
And
bring
when
it
did they
back
tell
to you.
this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Koepsell's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at
Sustained.
this time.
Okay, you were concerned about the case and you wanted to call her.
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Objection. Irrelevant what her statement is.
Irrelevant.
Did you have a conversation about your phone?
Yes. I asked her.
Objection. Answered.
Overruled. You may answer the question, ma'am.
Judge, did you call for a yes or no? She said yes, and now I don't know quite what's pending and how to object.
Did y'all have a discussion about your phone?
If you didn't hear that, Mr. Jhaie said, first he asked her a yes-no question, then she said something else. I don't know what question is pending. I don't know what I can object to.
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Koepsell was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was...
Excuse me, can somebody call the manager? I have a phone to pick up. I was told I could come here and pick up my phone. I don't know who you need to call. It's been 11 hours plus my nap time.
Supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs.
Oh, sorry, this is the, the cash window. The phone window is 2 windows over.
So we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
You didn't float up the damn stairs? No, well, I guess taking the elevator is a way to float up the damn stairs. They did float up the damn stairs. Look at that.
And I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
In an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and
Red shirt?
black pants.
His firearm was on his waist?
Sounds like she's describing a Star Trek red shirt. He had his, phaser set to stun. Red shirt, black pants.
The entire time, yes.
Okay. So y'all got off the elevator? Where did you go from there?
He brought me into a small room.
Interesting. Okay, Disney Mom asks, what model of phone did Sarah have? It's probably so out of date. From what I remember, somebody can fact check me on this, but I feel like it was a relatively recent, well, it's more recent than my phone. I think it was an iPhone 11. So not the most recent, but she's probably on a payment plan for it too, and probably owes a lot of money on it. Probably only had like the first month or.
And they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I
iPhone
could do.
XR.
Okay. So from the elevator.
iPhone XR. Thank you, Phil, for Dom Russo. That sounds even more correct. Or iPhone XL. In any case, that is around the time of the 11 then. Like if you're looking for where along the numbered phones it is. I have an iPhone SE second edition. Third edition? Yes. Whatever. It's maybe one past the 11, but it's a stripped down model.
Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video.
We got the recording.
You didn't go anywhere else
No.
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, you and I have watched the video,
Yes.
correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down?
Yes.
I bet she watched the beginning of the video 100 times, and I bet she skipped through the middle of the video 100 times.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again?
That's another good point. So, Christina Garcia says, and welcome to the chat, Christina, Brian was paying for the phone. And that makes sense as, hey, I need her to have a phone because I don't know whether she's going to be with the kid. But keep that in mind because several times in the trial, Sarah disparages George for not being able to afford a phone. If he had one, he lost it or mom gave him. And like slips in, or mom had to give him, like, it's somehow shameful that, mother would give his adult son a gift of a phone. Like, meanwhile, she's grifting a phone from her ex-husband.
Because we have to talk about that, referring to the autopsy.
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
She didn't say we just have to do it. She said George's autopsy came in and we have to talk about that. So I'm going to read you your rights. Because that's just what we do.
How did that make you feel?
Hey, BRB
Sustained.
Queen.
Were you trying to comply with the officer's demands?
Objection, relevance.
Overruled.
In every way.
That was a funny little... I'd like to get a screenshot of that. Let's see, 150.32 is what we're at. So I don't want to go much further back than that. Just gives a little side eye to the judge. I think she's trying to learn what sustained means. She's trying to figure it out from context, and she's on the edge of getting it, but not quite.
How did that make you feel?
Objection, relevance.
Sustained.
Were you trying to comply with
Hold on, I thought there was. Oh, maybe it's still coming.
the officer's demands?
Objection, relevance.
There it is. There it is. All right. What point of that is that on my stream? 106:49 of the stream is where I can pick up that screenshot. Thank you to the algorithm for being able to scan my voice.
Overruled.
In every way.
Were you trying to cooperate?
In every
In
way.
every way.
In every way. 150:26. That'll give us a chance to relive that at full speed.
Trying to comply with the officer's demands?
Objection, relevance.
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
Yeah, she doesn't even believe that. I think it was a Dr. G thing, but they talk about when your mouth is mismatched. So if you're trying to smile, but the frown is still there, that is one of the most obvious. The switch to the other. Bum, 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 bum. Wah. That's the total Price is Right loser face. There's a little bit of grinning at how well she thinks that she's executing this little story.
And when she said that, we just have to do it, you said just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Yeah, she said normal protocol, and Chelsey ignored that and just said again, just like we did yesterday, where I ignored what the fuck you said and went on to tell you what your rights were.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
But she didn't. Liar. Lying liar. Okay, let me just correct the record there. And I've done this on previous ones, but very quickly. The only person who said protocol that day to Sarah that was a member of law enforcement was the officer on the scene who, looking at myself. The only person who said protocol to Sarah was the officer on the scene who was taping off the scene. And she's like, why do you need to use the tape? Oh, it's just normal protocol, ma'am. Protocol. And from that point on, she parroted the word protocol to a lot of law enforcement, thinking that it made her sound like one of the gang. Oh, so it's just protocol that you're doing this? Just protocol? Almost trying to Jedi mind trick them into, I'm not a suspect then, so I'm just not allowed in the house because of protocol. So a little bit of self-soothing by trying to repeat what seemed like the best case scenario for her. And I managed to pause it perfectly on that contempt, half smile, half frown. But yeah, so she's lying. The protocol, she brought it up over and over again just because one of the initial cops on the scene that is doing protocol, but oh yeah, somebody dies, we tape off the scene. That's protocol, ma'am. That's the correct use of the word.
So she read the Miranda rights.
Boom
to
shicky.
you,
Except number 9.
except number 9. She
Number
read the
9,
rights, and then she
number
said, do you
9,
understand
number
what
9,
I've just read to you?
number
And you
9.
agreed that you had.
Yes.
But you were not read, having these rights in mind, do you agree to speak to me now?
Objection, relevance.
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you, do you agree to speak to us now?
I was never asked that.
I was never asked that. Well done, Sarah. No nomination, no Academy Award for you, but put her on the ballot. Boom shicky. Somebody call the police. Oh, that's what we're watching. Boomshicky's referring to the drunken sisters that were in the back of the car, I believe. If you don't take me to the cops, I'm going to call the police. Haley was making some poor arguments in the back. Made Sarah look like actually fairly intelligent. Now, that's alcohol for you, too. I'm sure in the moment Sarah could outdo Miss Haley. But Sarah needed a sister like Chelsey to fucking rag her. Chelsey was so great in the back seat with her sister. I pay rent and you're financially unstable. And you don't even pay Bob. I pay Bob.
The way that she acted, the things that she said.
Oh, we'll go full screen here.
The fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Objection, irrelevant, assistant custody.
Sustained.
She was in custody?
Owen's learning things.
By the state. And they're
She was in custody? Oh, this whole time I was trying to establish that this is supposed to be non-custodial. No, state doesn't argue custody.
Did you get the impression you were not getting your phone back if you didn't answer the questions?
Objection, irrelevant, assistant custody.
sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial
Okay,
interrogation.
but she wasn't aware of it. She wasn't aware she was in custody.
Doesn't matter.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to whether or not.
Let me finish. She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm.
Bad move, Owens. I wonder if we can even register it on Kraynick's face here. Judge Kraynick's trying to interrupt Owens and, keep him from going too far down the path of wrong. Obviously, he's noticed a flaw in his argument, and James says, let me finish. Let me finish. Yeah, that's going to go over well. Let's go back just a tiny bit further than that.
She was free to leave. She was in an enclosed small space. She was.
That all goes to whether or not.
Let me finish. She was being questioned.
Let me finish. Yeah, that's. Ooh. I'm sure Mr. J's just sitting there at the bench, like, I'm not going to object. I'm not going to speak. This is one of those Judge Judy moments where, when the other side is burying themselves, you just shut up and let them go.
By two lead detectives, homicide detectives. One of them was wearing a firearm.
As police officers do.
Being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation.
Okay.
I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
subjectivity matter.
Excuse me, based on
Subjectivity matter under the case law.
Based on
What does subjectivity matter? So just because the person felt like they were being fed, or felt like this was a trick, or felt like, oh, I thought you were my friend. I thought when you went and brought me McDonald's and asked me to rat on my friends, it was because we were buddies and you were going to help get us all out of it. I didn't realize that was going to be used against all of us in court. and I would still do, 6.5 years. It was all a big mistake, Your Honor. They tricked me. It was a vicious trick. No, your subjective feelings don't matter.
Based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice,
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, objection sustained. I apologize.
What does it have to do with it? I believe it's relevant. The objection's sustained. That's a great follow-up argument. It's almost like Sarah's follow-up argument for everything. Well, I still think it's wrong. All right, you can think that. Moving on.
Did you understand you were not going to get your phone back until you answered their questions?
Oh, enough with the damn phone.
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Objection, relevance.
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes,
Did you know that you were going to be placed in custody?
I did not.
That's a truthful statement. That's a very truthful statement. Why is this happening? Because George is dead. So if I didn't come here, I would still be home? Other than you just showing up while
Going to be
son is
placed in
home.
custody.
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
Yes, sir. Yeah, get ready, Sarah.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means.
As
It
much
did
as
affect,
impaired
yes.
means.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct?
Correct.
And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Koepsell that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Koepsell that afternoon?
Now or then?
Then?
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent, and I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal
Well
grounds
done.
need to be provided. What are the legal grounds of your objection?
I don't have any, Your Honor.
I know that she had said she didn't know what it was.
What are the legal grounds of your objection?
It's a good stipulation,
You may
Mr.
proceed.
Judge Kraynick.
And you understand that you're charged with second-degree murder in this case, correct? You're
Thank
facing a
you.
potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
I don't
Okay.
know.
And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements through State's Exhibit 1, correct?
So this is Mr. Jhaie getting on the record that we have 4 years of testimony that this was a terrible accident. Oh my God, I can't believe, I just fell asleep. I fell asleep. And now on the eve of trial with a new lawyer, it's suddenly battered spouse. And I've got Michael Brannon, who was in the Marsha Thompson case. Marsha Thompson was law enforcement. I want to say like a custody officer, not a police officer. But in any case, she had a 20-year claim of battered spouse syndrome and shot her partner. He was sleeping on the couch, and 6 of the shots were in his back. So, it's a pretty tough case. But Michael Brannon, the same expert witness that testifies in the Sarah Boone trial, gets signed up by James Owens. And, this is going to be the big defense. This is going to be, hey, he just won this case in July. It's only a few months later. We've got the same guy. Sarah, I think we got a chance. We're going to get off. I think we're going to give you that robust defense that you wanted.
Regarding the...
I would object to that. I'm not understanding what the question.
Mr. Jhaie.
But, so we'll go back. But this is basically Mr. Jhaie calling bullshit on the news story. And he's going to also call bullshit when they try and... Well, he's basically saying, hey, they haven't established what they need to. So I think there's going to be a third story at trial because he knows the overt act is needed for them to bring in the battered spouse defense at all. But he's bringing up the point that she's already on the stand. We have past testimony. She's going to impeach herself with her own testimony the more she talks. 158:43. So we'll go back about 20 seconds.
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements through State's Exhibit 1, correct?
Regarding the...
I would object to that. I'm not understanding what the question.
Mr. Jhaie.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she's testified to today, that particularly the things in conflict with Detective Koepsell's testimony. And
I'm going to try and do it, Tam Namasti. Get that speaking objection out of my house. Not in my house.
the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that.
I think the Kembe
appellate courts are going to be
fan.
very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witness today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all of the things that she's testified about today, because it is her intent to get this statement, all these statements, or the statement on 225 thrown out, so that she is not going to be cross-examined and impeached with it, so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence.
Sarah doesn't like that. What do you mean you agree? You're the one who's supposed to argue. Thought you were zealous with the side of Keene.
I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now if he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. Jhaie?
I am not specifically asking her what she said that was different, and obviously if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
Great answer, Mr. Kraynick. Basically, the specific wording of the question is incorrect, but I'll allow you to try and reword it because there is merit to what you're asking. So ask it a different way. Do you intend to testify differently at the trial than you're testifying now, or is this your final story? I think that's worth getting on the record.
You gave
Sarah
statements to
Boone.
an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences?
Margaret Adam makes a good comment. With so many verdicts being overturned in the USA, fingers crossed that Sarah's appeal goes nowhere. Margaret Adam, have a look at the Let's Play live that was done, I guess, was it last week? It has the drunk sisters we're talking about, but before that, we spent about an hour watching the Florida 6th District Court of Appeals tear apart. I guess a lawyer just did a really bad appeals argument. Cited a bunch of cases without citing why they were relevant to his case. In any case, the 3-judge appellate court, I don't know, they don't take bullshit kindly. And if Sarah's appeal gets to them, if they don't just reject it outright, I think it's going to actually be fairly entertaining to see them pull it apart, because it's not a great appeal. Like, it's probably as good as an appeal can be in her case, but it's not great, and the appellate court judges don't mess around. They're not pussyfooting with lawyers. They're not, I don't want to embarrass you in front of the jury. There's no jury. It's them. And they're like, why are you arguing this? Case law settled on that. Morgan v. Morgan says you must advertise in every video. That's already clear. Sponsored by Morgan v. Morgan.
In those statements as to what is in the statements you provided to law enforcement on February 25th of 2020.
Yes.
And
Margaret Adams, apologies in advance, but when you start saying, damn it, Margaret, and Margaret's going to get disparaged a lot before we get to trial. Owens buttons it up a little bit by the time they get into trial, but everything that goes wrong between now and the trial, I'm sorry, Your Honor, Margaret was supposed to get that for me. Margaret didn't print that out. I'm sorry, Your Honor. So it's not you, it's her.
Understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms.
Mr.
Boone
Jhaie?
return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay.
Just argument. I'm here for an argument. Oh, this is abuse. Arguments down the hall. Oh, sorry. Yeah, fuck off then. We still have our motions for hair and cosmetics coming up very shortly. I think we're about 15 minutes away from the motions for hair and cosmetics, so don't go anywhere. Stay tuned.
All right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
Hair and makeup motions sponsored by Skittles.
Mr. Owens, it's your motion, sir. You may proceed.
Skittles and cigarette ash, the makeup for every prisoner's court appearances. Well, look at Owens just pouring the water. Somebody brought this up in the chat at the beginning, but Sarah gets nothing. This is probably why she wants snacks. She's just looking at like the abundance going on over on James Owens' side of the desk. She got 4 waters there. Your Honor, Ms. Boone would like somebody to try and fix her
That's
hair.
my understanding of the law regarding Miranda.
Paul Mitchell.
First issue was the defendant in custody, was the suspect in custody? Was
Can't get Paul Mitchell. We'd like at least Fantastic Sam's.
it a custodial interrogation? We have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And
I may be incorrect. This might be where the judge takes it upon himself. And so earlier I said he'd seen the video. This might be where Owens compels him to see the video. And then the next video we'll be watching today is where I think that's it. And another thing to point out. So up till now, Judge Kraynick's been taking this. Well, and he does the whole time he handles the case. He's pretty, buttoned up. And my point, once he sees the video, I think that's when he gets the idea to start bringing in the students from the class he teaches. Because he's got you'll see it, but during the trial, there's 4 people, different people each time. They get to sit behind him. I'm sure he told his class, I've got a wild trial. You're not going to believe it. If you want a lesson in how to stay stone-faced and not react to some of the wildest testimony you've ever heard, I'm going to bring you up here. You're going to sit back here. You're going to listen to the testimony. We can talk about it afterwards, but I don't want you reacting. I don't want you giving any indication of anything being funny. But I'm telling you right now, this is going to be a funny fucking trial. That's my speculation. I don't know that for sure. I think after he sees the interrogation, that's when he gets the idea to start bringing in the interns.
I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances.
But they don't.
Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession.
It's not fair, Your Honor. They should be trying to exonerate my client, but instead they're trying to make her look guilty.
Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive.
Hey, Nana 4,
Prior
welcome.
to Miranda, you cannot trick.
You cannot trick.
That right.
Your Honor, in the statute of trick versus treat, you cannot trick a client when you come in for Miranda.
Is fundamental.
Trick or treat, smell my feet, give me something good to eat.
You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement.
Sarah would have loved to have been seduced into giving a statement.
And the law is clear. When that happens, we've got to punish law enforcement to correct that.
You know, I've seen a lot of body cam videos, a lot of interrogation videos. I have never seen... Okay, that's not true. I've never seen one where they've tried to seduce a confession. I have seen some where the law enforcement guy is getting into some shady, harassment and fireable behavior for being touchy-feely and that sort of thing. But then that's not somebody trying to get information. That's somebody that's trying to be corrupt and looking for a complicit partner. But
type of misuse behavior. It's illegal.
whenever I see Dorgan's name in the chat, it reminds me of Dorgan and Dorgan. Dorgan and Dorgan doesn't exist, but it sounds a lot like Morgan Morgan that has over 1,000 lawyers at their disposal and sponsors almost every other law and crime YouTuber, but not Dan D True Crime. So Morgan and Morgan, come on. If you got the bucks, why aren't you sponsoring my podcast? Morgan and Morgan.
So you got Detective Koepsell on the one hand, I got to read your rights. And you have a right to remain silent.
That's a good right.
But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you.
No. Not we have to do this, we have to talk to you. We got the autopsy, and we have to talk about that. So I'm going to read you your rights, because that's just what we do.
Now, that's confusing.
Good point, Kelya. Kelya says they trick the shit out of Lazarus. Schmida, Stephanie Lazarus, friends with Schmida. But yeah, great point, Kelya. They trick the shit out of Lazarus. You'd think she would know if it was actually illegal. That said, she did go specialize in art crimes, so she might have lost track with how criminal investigations proceed and the statute of limitations on murder. But Stephanie Lazarus, fun case. I think True Crime Losers, great to listen to if you're familiar with the case and you just want to hear some storytelling about it. But there's also some great... You know what? Zuma did a couple good breakdowns of the video too. The interrogation itself is really fuzzy, so it's almost better to be watching with a commentator that can help break it up and discuss it, because it's a little... It makes the resolution of the Sarah interrogation look sharp, is what that video looks like. But it's compelling, and with somebody who can break it down. I think Behavior Panel might have even done one, and they're hit and miss, but I think that one, they knew enough of the case that it wasn't speculation, so they were able to apply the facts of the case to the body language she was exhibiting, if I'm remembering right.
That's deceptive.
Silence of the Goats,
There's
welcome.
nowhere in policy that should be allowed or is allowed. There's nowhere in the law
Stephanie
that
Lazarus
should
is
be allowed.
free?
It's actually illegal. To
Shemita.
tell a suspect, we have to talk to you. We just have to. Before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy.
It's like Tracy Andrews in the UK is also free. It was part of my little Women's of Crime montage. Stabbed her husband 37 times, appeared on TV news in the UK. Oh, we got, a little road rage. They stabbed me husband. And, it turns out that she just stabbed him with a penknife 37 times and lied about the whole road rage thing. And she's free. Remarried, changed her name, got some plastic surgery, but...
Sarah Boone did not have to talk further about what had happened. But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of "we have to read you the rights" was made before "we have to talk to you." So your argument...
Paul Clank puts a challenge of who can name all the Torres brothers. Give you a minute. I'm not going to say that I can, but I do remember that there was Juan, or John, as Sarah put it. Pharrell, there would have been Mo as well. Mo was the one who Sarah said, "Hey, George is beating me up. Why don't you rearrange his face so he can't be recognizable?" I don't know. I think the other two were sisters, if that's correct. But chat, you can fill me in if I've missed any members of the Torres family. And yes, Pharrell Torres, that's the one that we saw in the video from that commentator who has a duck as a co-host. Interesting choice of material for a guy who has plenty of material that would be very interesting to hear his commentary on. But yeah, we got to see him reacting to that video, so, welcome. Toe in the water there from the Electrified Rail Company.
Transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone
Yes, Rita, that's
was
exactly
brought
it.
up there under false pretenses.
It's a long shot to get the interrogation thrown out. And, on the one hand, like Kelly's correct, it's such a waste of time because none of it's successful. It was worth him fighting for, because if he managed to have it thrown out, then that would have improved the case, maybe they would have gotten a slightly better plea offer from the state. But it was such a long shot to ever have it rejected. It was just basically a much more useful fight than the one we're going to hear for cosmetics and hair. And
A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my
Isaiah.
rights, but then saying, we have to talk to you.
thank you, Detective
We just
Wilberforce.
need to do it. And then she reads the rights.
Vincent,
Right there within a few seconds of each other.
big family.
That's improper, it's illegal, it's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that
Nana is 4. Thank you for the correction. She says Stephanie's parole in 2024 was denied. So, not free. Feel free to weigh in on this if you have information so we can get to a consensus. On a past stream, we had a debate over whether urine was sanitary, and I think the final word was no. It was Allison, the DNA doc, that was able to get the final word on don't drink your own pee. You learn things on a Dandy stream,
she came down under false pretenses.
Victor, not Vincent.
Coupled with the fact she doesn't have the 9th question.
Number 9.
If you think about it,
I love the way he lets that sit. Like, that is like the mic drop. She doesn't ask. She doesn't ask the 9th question.
coupled with the fact she doesn't have the 9th question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then do you understand what
The 3 or 4 questions are the ones that are, he even kind of acknowledges that he knows that those are the ones that are really the important ones, and everything else is over and above.
I just read to you? I'm paraphrasing.
Yeah. And that's what Chelsey did. She
But
paraphrased.
then Detective Koepsell goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak
Oh,
with
we can't
us?
get back into this, Kelly.
That
Yeah.
is,
No, this is settled law. Don't drink your own pee. Even if it's an emergency, find some other emergency liquid. We can't get back into that. Every stream's going to turn into pee, do or do not drink. We can't do it. We can't do it.
the time of free choice. That is the time of decision for Sarah, to be given that opportunity. But the way I understand, Detective Koepsell
Hey,
had the
Margarita.
autopsy. She had the blunt force trauma.
Welcome.
Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
I just realized my headset might have been
The
so
United
loud.
States Supreme Court
it
has
was
said
causing
that
an echo.
confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th, they are allowed to use subterfuge and deception to
This
get
is
somebody
forever?
to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Koepsell's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Koepsell's, and of course she has a bias and interest in the outcome of the case, whereas Detective Koepsell has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge?
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
Judge,
Before you go, Your Honor, I have one more thing.
for the record, there's 2 exhibits that I tried to introduce. They will be admitted
Correct.
to the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
No dog in this fight, Your Honor.
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
And Judge, I just want clarification, but, she's here today and she's in handcuffs, so she has difficulty writing, she has...
Let me just interject for 1 second.
Let me stop you right there.
She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature.
I think the suitcase is going to be right there, like just, feet from her. Mere yards away. I wouldn't, you can't just assume there's no weapons or anything of that nature in the courtroom, Mr. Owens.
She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger, and people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over
No,
here?
that's your table, sir.
That's my table, closest to the jury.
That's your table, sir. Tell me you've never tried a case in 6th District without telling me that you've never tried a case in the 6th District, Mr. Owens.
So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom
They're never going to
first.
see her walk in and out.
So the only time is when she testifies. So I
I
guess that only, I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's walking from the defense table to the...
The Bayou Tapestry was mentioned indeed. Detective Wilbefit's asking in the chat. It was Charles Grieve bringing up that Sarah's haircut looks like a chopped Norman haircut from the Bayou Tapestry.
Witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and
Absolutely. Barbecue Queen, Foghorn Leghorn. Your Honor, I don't think she needs leg restraints. I think that she's just a chicken hawk trying to hunt for chickens.
I assume the tables are going to stay here?
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. There are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Okay. Anything further as to that issue?
I don't believe that's case law authority on the issue.
Okay.
Beliefs.
All right, thank you very much.
Simple argument for Mr. Jhaie. I don't think that's the case law. Okay, thank you. Of those 2 arguments, what do you think is going to be the most compelling to Mr. Judge Kraynick?
With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it'll be transported with her in the morning each day of trial. Okay. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial, just the arguments in there.
And the Estelle case that you cited spoke to being dressed out in a prison garb.
Prison
doesn't really
garb.
address a prison guard and shackles. It doesn't address any beautification or
It doesn't address any beautification. Oh, you're so diplomatic, Mr. Kraynick.
anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Which is why she's not wearing it into court already.
Well, I'm going to have the two paralegals here.
The girls. That's Shelby Anderson and Lauren Henderson, the two paralegals.
I say the paralegals. One's a lawyer now, and
I say paralegals. One's a lawyer now. Asshole. Then call her a lawyer.
the other is a consultant, but
I think it's Shelby Andrews. It's the jury expert, so legal expert, but yeah. Here too referred to as the girls.
they're females, and they can...
They're females. Thank you. In case I didn't make it clear. You know, Your Honor, they're females, so they can do it.
They're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the...
He wants to send the beauty team into the back room, so the other inmates are going to be back there just sitting, waiting to be brought in. And Sarah's going to have like her hair and makeup team, like, you know, she's a star.
Inmates.
Can she be allowed? Can the two females on the team can they be allowed to apply some type of makeup to Ms. Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but...
If you want to try to do it here in the courtroom, that's fine. But be advised that, you know, when we start court, we start court. So, and I intend on starting at 9 o'clock every morning. So I'll have pleas every morning in other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend travel to the jail with you, sir, Mr. Owens.
Granted for clothing. Now, this gets wasted the very first time he gets to bring her clothes. He brings her something that's exactly the same blue as her jail scrubs. It's a slightly different cut, and she gets to wear an undershirt with it, but it's a really poor first choice.
To take the measurements, you'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas.
Oh, that's a great
point. But if you want to attempt to have...
This is Forever Wander says, can you imagine how funny it would have been if they went full glam with Sarah for the trial? Like, makeover! I'm thinking Ali Sheedy in Breakfast Club, which I think she looked better as a goth girl, but goth Ali Sheedy, there's a lot, you know, the stringy hair. I could totally see that being the beginning, and then trying to Molly Ringwald a version of Sarah by the end of it. In a pretty pink dress with pink shorts.
Members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints, but the hand restraints will be removed.
Judge, and then I think there's something about hair as well.
I think that it falls under the same.
Okay.
analysis.
Needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is the, I'm sorry, yes. Yes.
The last item for today? Nope. There's something more. The look that James has given to Sarah, too.
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand.
James Owens doesn't get it. He doesn't understand how there's a reason why it's contraband in the jail. I don't know exactly what that reason is, but I imagine there's something that, you could hide something as makeup and then have it transfer, scrape it off the face and it's drugs in the makeup, or, who knows. But whatever it is, it's not allowed. Your Honor, it's just a little makeup. Just a little lipstick on a pig.
But
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined.
I don't understand how a little lipstick on a pig is going to cause a problem, Your Honor.
After she's returned to the Orange County Jail facility.
Into Sukaroi.
Okay.
Margarita, that's an unfortunate
You'll get
spelling
an order
error.
with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my Jhaie had emailed all y'all, I think, last week after.
All y'all. I don't think he gets out very many all y'alls. All y'all. 2158.
Moving now to the state's request for protective order. I've reviewed that. I need more. I need to understand what
I did again.
you're looking at,
Sometimes
Mr.
I go
Owens.
forward instead of backward. Oh no, okay, that's them.
So
Basically, the jail came up and don't let them finish this court case and let her get her
the
makeup.
Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband, they don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined.
Tam Namaste says she wanted to be like the fake socialite trial. Anna can't recall her last name. I think that's Anna, like the God. I know who you're talking about. She. There was a Netflix thing about her, quite conventionally attractive, and used it to pretend she was part royalty, like one step removed from royalty, to move around social circles in New York, some kind of fashionista. But yeah, she wore designer clothing every day and makeup to court. But I think it's because hers was a fraud, not a murder, right? Was there a murder involved with that? I thought it was a big fraud. Lots of fraud. Anna Delvey, yes. Thank you, Margarita.
After she's returned to the Orange County Jail facility.
Okay. Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my Jhaie had emailed all y'all, I think, last week after it was filed, that said
All y'all.
this would be added to the hearing for I guess that was filed on Monday, forgive me, had emailed y'all and said that it would be addressed today.
And that was relating to me subpoenaing and listing I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome in conjunction with self-defense.
We're aware.
And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times
Hey,
prior
Robin.
to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges to be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of jail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear.
That's a common theme. You just claim the defense and then you get bonded out. So we're going to try for that, but I know there's only a week before the trial, but, you know, if we could bond her out for a week. Where are you going with this, Owens?
Hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons? How would that not be protected by work product?
Well,
to whether or not it was a decision.
If it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charges to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
What the fuck?
Okay. Response?
Make it make sense, Mr. Jhaie. Make it make sense.
Opinion work product, that is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant.
Okay.
What is relevant in a
Mr. Jhaie doesn't understand either. Good, good.
self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate,
This is
have all now,
October
I
2nd.
learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. I mean, the state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and were just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case, the state attorney does.
You'll have a written order on the motion, protective order for tomorrow, by tomorrow as well. Anything else, state, we need to address?
You have a written order due tomorrow.
And again, been conducting motions all afternoon.
So I changed the ticker to October 2nd. I think the next video we're going to watch is October 7th. So there's not very much time in between when this one ends and the next one we're going to watch. And that'll be all we watch today, because that one's also a 2-hour video. And since we're not doing a ramble tonight, I'm going to be locked into soccer. First the Canada-Bosnia-Herzegovina game, then the USA-Paraguay game. So that's a double-double for soccer for me. So football for the rest of the world, soccer for North Americans.
It appears that we are set
hosting
to
the cup. We can call
allow
it
the
that this
defense
time.
to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
So Dr. Brannon, he ends up being quite an effective witness. Even though he's testifying for Sarah, he testifies as an expert and is relatively unbiased. He gives his opinion freely. The reason James Owens hires him is because in July 2024, Marsha Thompson is the one who shot her spouse, cohabitant, maybe husband, regardless, sleeping on the couch, 6 shots into his back. And she was acquitted because of a 20-year history of battered spouse syndrome. And Dr. Michael Brannon was able to help testify to basically the mental state that you would be in from such a thing. But they basically tried cutting and pasting her experiences on Sarah, and we see in the trial how poorly it goes. But this is interesting because this is Owens fighting to bring Michael Brannon in, and he's not nearly as Team Sarah as Dr. Julie Harper is.
At 3 p.m.
Okay, that's still set at 3 p.m.
Yes. There will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking...
That's interesting. So, Mr. Jhaie, you don't realize how different it's going to be. I'm just going to go back just a half tick there, because based off of what I just said, Mr. Jhaie says, I don't see how this is any different than Julie Harper testifying on it. When we see the two of them testify, it couldn't be more different. Dr. Julie Harper is a pure, I got hired by this side, this is the side I'm testifying for, and everything I say will be in deference to that side. Michael Brannon gives his testimony that James Owens expects, but when Mr. Jhaie asks, hey, could George have been a battered spouse? Oh, yeah. Oh, for sure. No, that lines up. Yeah, no, those are narcissistic traits. Yeah. So, good for Mr. Brannon.
Be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida, virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay, all right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, y'all's expert, by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay.
Well, this is Forever Wander, who says, I missed Brannon saying that. I really do need to rewatch the trial. That's exactly why we're doing this. Some of the trial makes a lot more sense in context of what we know now. I remember in the moment of watching it and, how we were basically freaked out of how brief some of the questioning was in some spots. But, we didn't know when we were watching it live how the closing arguments were going to tie everything all together. And I think they did a fantastic job of both painting the picture and putting together the puzzle of what happened. Paint, puzzle. But yeah, they used the court case to bring all the tools. They brought in the puzzles, brought in the paints, and the closing arguments just, painted the picture and put together the whole puzzle, except for, that one crazy missing piece, which is, Sarah's version of the truth.
Things are the only 2 things that I believe we have left.
Robert
prior to
Tellis
jury
was a
selection
great
on Monday.
testimony.
If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could...
Colloquy. I don't know exactly what the word is, but from context, colloquy is basically Judge Kraynick officially getting on the record that the defendant knows what the consequences of going to trial are, knows what the maximum sentence is, knows that life means life. So that's interesting. We're going to get that pretty soon here in the trial because it happens before the trial starts.
Send me that. I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion in limine.
Okay, all right, appreciate it. All right, thank you all very much. We'll address scheduling of any motions on Monday, and it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right, thank you all very much. We'll see you Monday morning at 9 a.m.
Absolutely correct.
Thank
Nana of 4, who says there is no parole in Florida. And that's, we'll see if he makes it clear at this colloquy hearing with Sarah. Because, it's implied, but I did see a different appeal where I think it was in Massachusetts, but the one side was arguing for the fact that, there is no parole for life, so it's implied that it is. And it's like, well, it could be implied, but did they realize that that was the consequence? We know it legally, but I can't remember the context of why it mattered in that case. I do remember that it was Massachusetts, so it didn't really matter to Sarah's case. Looks like we've got frozen video from this point on, so there's no reason to stay with it. Yeah, goodbye to you and hello to you. We will come back make sure it's at full speed. Last time I did this, I was at half speed and waited twice as long for the show to start. We can skip ahead a little bit until at least... Well, this is interesting. So Mr. Cacciatore and James Owens are having a little chat before trial. Well, let's correct the date too. When was this? Also October 2nd? Better make sure that I'm not just watching the same thing. I can't do that. Oh, this is the same thing. Tricky. Okay. One was Court TV, one is Law and Crime. Yeah, okay. That won't let us stop our broadcast day. We have more to watch.
Yes.
Okay. That's 13.
From the decedent if he gets out.
There we go. Okay. Close that. We will... October 16th? That seems like it's too far. Ramono brings up True Crime Loser, and this I've been hyping this a lot for people who are regular true crime fans. And go to the bathroom, do what you need to for the break. I'm going to maybe take a quick bathroom break once I get us set up on the right video here. But Ramono says True Crime Loser's Crazy Face Lazarus content is spit your coffee out of your nose funny. And I agree. I think the more yeah, I really do need a quick break. The more familiar you are with certain cases, the more you can enjoy his storytelling of the case. Initially, I was very frustrated that I wasn't getting clips of the cases when he was talking about them. Like, I was like, this would be a perfect time to throw to a clip. Okay, I'm just looking at my screenshot here. Look how happy Shelby Anderson is to see Sarah come into the court. Like, look at you. You got your blazer. Oh, girl, you're looking smart. No jury in the world would convict you. You're killing this. You're killing it. Okay, let's see. Is there anything in between October 2nd and the 16th? That's the 16th.
You called 911?
That's October 4th. This is the one we're looking for. Sarah comes back on the stand? That can't be right. No, this is the... Okay. This is what we watched. Long Crime Trials just got the video out 2 days later because this isn't the live stream. Okay, and the one prior to that is October 2nd. That's the one we watched. Okay. We are going to October 16th. The great thing about October 16th, this is the snacks motion. We're going to get her motion for snacks. She wants peppermint. She wants Pop-Tarts, maybe a juice box. I understand she gets a peanut butter sandwich. Your Honor, it's a long day. She's been staring at my little stash of water. She's asking if she could just have just a few snacks for her low blood sugar. All right. Okay, we're on pause here. Anyone who's gone, come back. I'm going to press play because I know there's more than enough time. Then we can see the clock moving at least. This is 60 Minutes. I'm Edward R. Murrow. Okay, I'll be right back, taking a bathroom break. I think we don't have very much time. In about 20 seconds, Sarah looks thrilled. You have that to look forward to. I'll be right back. Oh, yeah, she's feeling it today. Okay. Oh, my God. Okay, so Winona Judd has been mentioned in the chat. Winona Judd will always be part of a fairly unfortunate joke from the Larry Sanders Show that still cracks me up to this day. But Larry Sanders Show was we'll pause it on a funnier face for Sarah. There we go. That's better. Larry Sanders Show was a show that kind of parodied late night talk shows with Gary Shandling as Larry Sanders' late night host. Maybe I'll go main me for talking about this. Boom, we'll do that. And maybe I can go to that page. Just so there's something interesting for people who don't want to hear a side story about the Larry Sanders Show. Anyway, Hank Kingsley, who was played by Jeffrey Tambor, who a lot of people will know from Arrested Development, he was the co-host. He was like the Ed McMahon to the main host. Anyway, he was always kind of the butt of the jokes from Larry, and one of the times when Larry was busting Hank Kingsley's balls a bit. Well, do you remember the time that you introduced the Judds as the Judd? There was only one. So, yeah, the Judds were really big in the 80s, but I know that there was a mom and daughter duo, country music, I believe. And, yeah, eventually the mom couldn't keep performing, so he introduced her as the Judd. And, yeah, that's not great for TV late night host. All right, moving on. There's still no audio in the hearing. There's one of the girls. That's Lauren Henderson sitting behind Tony Henderson. There's Sarah in her high-collared blouse and blazer. Just feeling fantastic. Hands-free, shuffling papers. Mr. Owens is like, just be quiet. You want to look serious. See what I'm doing? I just put my fist against my face. Copy us. Don't touch me. Seriously. First time I show up to court, you have her hands uncuffed and she's putting her hands on my back. Can I get a bailiff? I think this part too, if you're a fan of the Sofa Squad reporting live from my sofa, Paul does some great bad lip readings of Sarah at this hearing, talking to her lawyers, mostly about how she's not wearing any socks and can you smell my feet? Oh, it's just so funny. Hey, Blue Giraffes, welcome. Welcome. But yeah, definitely check out. I think his Sarah stuff was good, and that's what got me in the door for his lip reads. But his Donna Adelson ones were off the charts. Some of the lip reads from that trial, I probably took in more content from the Donna Adelson trial through the bad lip reads that Paul did on his channel. So there's a little shout out and recommendation there. Oh, Meowgarita's got some trivia gold in the chat, and I've missed it. So scrolling. Oh, something about Gary Shandling. Okay. Did you know Susan Sarandon was a writer on that show? Susan Sarandon, I didn't know. I did know, God, there's a few people that really went on to stuff. Phil, who played one of the writers in the show, went on to be a lab tech on CSI, the Vegas one with Grissom. Janine Garofalo was on the show, but she was already rather famous before that. Who else? There was a few people that were like relatively quiet that went on to big things from that. Oh, from Kids in the Hall, Scott Thompson joined the show in the later years as Hank's assistant. He was so good. Yeah, Kelly, I can't hear or I can't see Donna without hearing Paul's voice now. Like Paul's voice, he embodied Donna so much that if I'm reading her text and her pictures on the screen, I just hear Paul saying it. I just hear Paul. Oh, look at my Wendy. Look at my Wendy looking all beautiful, walking up. Don't look at me, Wendy. Don't look at me. Oh, I had a little peek. And I'm doing a terrible job, but yeah, love his impression. So these must be, these are the privacy panel desks. This is going to be the last view of Sarah we get, because once the jury gets impaneled, they're here where the camera is. So this is kind of interesting to know what it looks like from this view. Also, the date, if this is October 16th, this means Hurricane Milton has hit. Hurricane Milton hit, gave them the extra week because they were scheduled to come into trial October 7th. So this is now the late start, and they still haven't started. This is still, I guess, the final motions hearing. See if there's anything in the description. Florida woman Sarah Boone is accused of killing her boyfriend after she allegedly zipped him up inside a suitcase and left him to die. George Torres Jr. suffocated to death inside Boone's Winter Park home. Boone claims they were playing hide and seek. She forgot he was inside the suitcase, and she fell asleep. Video evidence from the night of Torres Jr.'s death shows the victim inside the suitcase yelling for help, while Boone records the video and laughs. Boone called 911 the next day saying her boyfriend was dead. She was arrested for second-degree murder. I'm Doug Llewellyn, and this is the People's Court. These litigants are not actors. Sarah Boone is a real piece of work, and she has agreed to have her case heard here in court, rather than taking a plea offer that would have seen her free on the streets by 2034. Miss Boone, sipping a glass of water now with her free hand, will no longer be this free in any capacity as a killer.
William Jhaie for the state.
William Jhaie for the state. James Owens for the defense.
Henderson on behalf of Sarah Boone.
Tony Henderson on behalf of Sarah Boone.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and
She's wearing a gray suit and a white blouse. She is out of custody, unshackled, and fully prepared for this hearing.
unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please?
Kevin Beck on behalf of Sarah Boone.
All right, thank you. All right, we're here on a litany of different...
That's Kevin Beck. We'll go back a little bit. Anyone who wants to see what Kevin Beck looks like, because we only really see, well, we don't see much of him. Kevin Beck was on her shit list in the phone calls we saw. Okay, that's Kevin Beck. Let's see, I need to move the video. Do something like that. Maybe there. Okay. So yeah, right beside me is Kevin Beck. That's Lauren Henderson talking to Tony Henderson. That's Kevin Beck with his back to the door. James Owens going to confer with Mr. Beck. Kelly says, I'm okay with missing Kevin, actually. And I guess the response to that, it's, were you guys missing Kevin? No, I wouldn't say we were missing him. We're back to Sarah Boone with her glass of water. Sip, sip, sip. Oh, this is so much better than OCC water. This is water of freedom. I used to drink water from a spigot.
William Jhaie for the state.
James Owens on behalf of Sarah Boone. Tony Henderson on behalf of Sarah Boone.
Kevin Beck getting back into the courtroom late.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please?
Kevin Beck on behalf of Sarah Boone.
All right, thank you. All right, we're here on a litany of different matters.
A litany.
Multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force, filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So, State, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
That's right, Kelly. Yeah. Kevin Beck volunteered. Anything you need, even if you want to declare ineffective assistance of counsel, just I'm your lawyer. That said, let's get to the reality of that. Probably what happened is she was complaining, and she's like, well, maybe I should sue you guys for ineffective assistance of counsel. Yeah, you could do that. That's your right. Everyone has that right. He said I could do it. Mr. Cacciatore looking over with a keen eye at what's happening between Mr. Jhaie and Mr. Owens or Mr. Henderson. Phil Hartman co-wrote the Pee-wee stage show before the TV show. Before Pee-wee's Playhouse, there was a stage show? That's a pretty interesting fact there too, Meowgarita. Thank you. I'm the Hamburger Man. I remember Pee-wee Herman from the Cheech and Chong movies. He played the Hamburger Man, and he liked to powder his nose a little bit in the movie.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Koepsell and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion.
Hey, CL McIntyre, welcome to the chat.
State would move A for identification purposes, in as 1 for the purposes of this hearing.
Responses to what was pre-marked as A.
Meowgarita, did you know that Rob Zombie was a tech on the Pee-wee
What
Playhouse
was
show?
pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this
A
hearing
roadie
is
of
the
some
deposition
sort.
of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as states C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire.
Addie, the Pop-Tarts and peppermints are part of a motion that gets made in the hearing we'll be watching today. James Owens asked for, Your Honor, my client, she gets woken up at 2:30, 3 a.m. Her bunk gets kicked, and then she's down in the pretrial center, and she's down in the basement, and I think they have a sandwich. But, Your Honor, my client would like 5 peppermints, 1 juice box, 2 cookies, or a Pop-Tart. Just some snacks to keep her blood sugar up and keep her spirits up during the trial, Your Honor.
Defense cited numerous cases and spent some of their time in their response about the ability to voir dire that.
Look at that swoop. That's what the hair and makeup team were able to do. This is the big, and that's why Shelby Andrews looked so excited when she walked into the courtroom. Like, look at you, transformation. Oh my God, this is Ali Sheedy at the end of Breakfast Club.
That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story. again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what...
That's a great point, too. So if they're going to go into battered spouse, then that matters for how they select a jury, because he's going to ask, have you been a victim of domestic violence? And probably move to strike jurors that have a story that's too similar to the story Sarah's going to tell. So he needs to know what her defense is. And Judge Kraynick brought this up in the last video we watched. It's not a game of 20 questions and pop, this is the defense we pick at the last minute. You have to say what your defense is. And if you're giving an affirmative defense like battered spouse, which means the onus is on you to prove that your client was battered, then you don't just spring it and, kind of develop the story as it goes in court. You get those facts on the record prior to court, and, well, here it is.
The defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony is we were having a good day. Now what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we're having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually, it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the...
Dor asks a great question. Kelly shouts it out and helped me notice it. Dor 2413 says, after seeing that she was a batterer, along with killing George, why did the prosecution offer Sarah that great deal? My speculation on this is not so much a Sarah answer as a Florida answer. I think Florida has a statute of saving money. And if there's any way that they can save the money of a trial by getting the person to plea, from what I see, the pleas are fairly generous. The state is pretty, no nonsense about your time is your time. And, your crime will be all over YouTube because we don't give a fuck. You want to commit crimes in Florida. But they're also fairly lenient on, you're going to save us money of not having to prosecute. You're going to take the perfect, we'll give you, this, and this. And it seems like they're just predisposed to doing that in all cases. And there was some argument at the time. I remember there was discussion over, like, would the Torres family have signed off on it? They were probably aware of how scorched earth Sarah was going to go and knew that George was going to be dragged through the mud, that Pharrell was going to be brought up, and that this whole, onion was going to be, it was just going to be hurtful. So there was an advantage to having her just take the plea. That's all my speculation as to why that plea was offered and why it could have existed in the first place. So I don't think it's so much because of Sarah as much as that's just protocol.
Antecedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time, when he starts to...
This is also great because you don't get to see Sarah's face during most of the evidence being produced. This is really the best opportunity to see how she's reacting to the facts of the case being read out. It almost looks like that James Owens is the criminal based off of just the body language here, that Sarah's the dispassionate lawyer and James is like, quit bringing up my crimes.
Say, I cannot breathe. Now,
oh, you guys probably can't see. Oh, there's a little James there. Okay. Forget that I sometimes have a different view than I've given you.
she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer. But she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him...
Victoria Carmen, great point, and that kind of piggybacks on what I'm saying. Mr. Jhaie gave Stephen Stern a great deal. Jen Soto's still free. I think, there's some aspects to being a criminal in Florida that are very unforgiving. There's other aspects that are quite forgiving if you show a little fucking remorse, in the words of James Owens.
In there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out, and she completely expects him to get out because her testimony is that he could get 2 fingertips out.
You're welcome, Kelia.
So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error, but this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking...
You can see James Owens kind of processing that too. He's like, fuck. That's right. We haven't done that. Sarah's just trying to put on a face, but if you look at James's face, it's a little bit registering on him how fucked he is.
The risk of error, but this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence.
Go ahead, sir.
Or battered spouse syndrome evidence.
Mr. J got distracted. Somebody was moving a chair or something. You guys heard a little bit of extraneous sound.
And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So
this is key because it means Sarah has to take the stand. Unlike a lot of trials where it's a question, is she or isn't she, is he or isn't he going to take the stand in his own defense? In this particular case, because of the battered spouse defense, because of the lack of battered spouse evidence that had come in prior to trial, the only way she can get in this overt act to testify battered spouse is to get on the stand. So it's almost like a chess move that the state is playing right here.
So she should have to testify before any of those things come in, and her testimony should meet the requirements of an overt act before any of this testimony comes in.
Yes, Disney Mom, this is the first day with her hair and makeup that was argued for at the end of the last video. And what Judge Kraynick said is makeup's not allowed. It's already not allowed. So, you're not going to put Contraband on. We're not going to send the makeup team back. But, you do have a few minutes before the trial. I'm going to start on time. I'm not going to give you extra time for your hair and makeup crew. But if they want to meet in, the hallway as she's being brought out and, fix her hair, yeah, that'll be granted. So this is the efforts of Shelby Anderson and Lauren Henderson, lawyer and legal expert, also the girls.
Be allowed to come in prior to her testimony. And under the case law that the states...
So no makeup, too. The makeup was still contraband, so what they probably did was like literal, okay, I'm just going to pinch your cheeks a bit. That'll give you some blush. We'll break a few blood vessels. And, yeah, jail makeup. Like, I saved some ashes from a cigarette that I had on my way in. You can use that.
It's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
That's another thing. So Mr. J's kind of addressing why so many attorneys had to step down, because there was a conflict of interest. You can't suborn a perjury. Basically, if you know something's a lie, you can't ask questions where you know the defendant is going to lie on the stand. At best, as an attorney, you can say, I'm not going to question. I'm just going to put my client up there and they're going to tell their story. And that's kind of the way that Robert Tellez testified with an attorney, but still as largely a narrative. There were a few questions or redirections kind of things, but he actually had an attorney with him as opposed to Sarah, who was going to be pro se. But yeah, I think Mr. J's just making that point that I remember when I watched this live, we did think that Sarah was going to have to do the narrative testimony, and Robert Tella's was a very recent trial. Sarah largely did do narratives. They were able to bring her back, like where James Owens, tell me about the day. Okay, tell me about the morning. And, shortened up the time frame and made it allowable. But yeah, it could have been worse if you thought Sarah was rambly as it was. It could have been a pure narrative. She could have just been up on the stand jabbering for a full week.
Thank you. All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
Good point there, Care for JC. The Tangent Crew titled their video, Harmony's Dad Gets Retrial, instead of using the killer's name. In a lot of cases, I prefer that. I think there's this... I remember when I started this channel, there was some thought to using Sarah Paulson rather than Sarah Boone as a name. For me, the reality was if I wanted to get seen by people who were interested in the case, I was never going to be the trendsetter that was going to get them to change how they're looking up the name. So I was kind of forced into going with the flow. But I think there's something to be said. If before the criminal becomes well known by their own name, it's a lot better. Like if Sarah Boone was known as George Torres Killer, I would happily title all my videos, George Torres Killer does XYZ, George Torres Killer does this. But that's maybe not the best thing for the victim of the crime if they don't want to be forever associated with the fact that they were George Torres killed by Sarah, as opposed to George Torres loved brother, George Torres, beloved dad, loved son. So I don't know. Interesting arguments all around. I think there's definitely some merit to not popularizing the killers by default anyway.
I'm a little confused, but I want to...
I'm a little confused. Perfect, because I don't know where you're going to start, Mr. Henderson. We'll just go back a little bit so I'm less confused too.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
I need to confer. I'll just take this time to roll up another medical cigarette. If anyone needs to go to the bathroom, Tony Henderson is conferring with his legal team. I have gifts of Pop-Tarts and peppermints on the
Judge,
side.
if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll have a more of an open-ended question. What is the basis, factually, of Dr. Harper's opinion? So if we were at trial...
That's a great question, Your Honor. Her opinion is not factual. Thank you for clearing that up in pretrial. That's perfect. We can just ignore her testimony.
Right now, for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component?
Well, sorry, Detective Wolbefit, Zed is Dead is a reference to Pulp Fiction. And Zed was the name of the... Well, there was a Zed on the keychain that belonged to the duo that sexually assaulted Bruce Willis and Marcellus in the basement of the pawn shop. And Zed showed up to help commit the offense, and as Bruce Willis was driving the motorbike, I believe his girlfriend asked, "Who's Zed?" And Bruce Willis said the iconic line, "Zed's dead, baby. Zed's dead."
Under 90.702 in order to get her to testify. We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step one under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know.
Okay, so some backstory here, and just to break up the speed of Mr. Henderson's banter with my own. Mr. Henderson is awkwardly trying to argue how people with the condition don't know they have that condition until they've been diagnosed with that condition by an expert. He's forgetting the fact that Julie Harper did meet with her several other times and didn't diagnose her with this condition. But further to that, he is, I want to say, mansplaining. He's, Judge Kraynick's obviously a man himself, but the concept of mansplaining, basically going into detail on something where the other party actually has full awareness, but still going into pedantic detail. Mr. Henderson's doing that. Maybe I'm even doing that describing it, but Mr. Henderson's doing that to Judge Kraynick because Judge Kraynick has an extensive history on the family court before he became a criminal court lawyer. So he's aware of battered spouse syndrome cases. He's aware of a lot of this stuff that Mr. Henderson is, I guess rightfully arguing in court zealously and keenly, but he probably has no idea how flat it's falling because of Judge Kraynick's actual experience with actual victims. But that's just something to pay attention to here as he argues for Julie Harper's testimony to be considered, the gold standard for the battered spouse defense.
That they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs.
Yeah, Rita gives me the mansplaining pass. Woo, I'm going to put that in my back pocket, pull it out for any time I'm commenting, but save it for when I'm in the company of friends.
Told and outside sources too. They are able to make a determination based on their training and experience. So,
but based on
thank you, Aaron,
the Akendo case, which is cited by the state as to
Akendo case. I looked this up he brought this up earlier with Judge Owens. I'll look up what the Okendo ruling is in the background, but it's a fairly fascinating statute as well.
What battered spouse is it's an ambit of self-defense.
Oh, never mind.
So
you explain it.
Under the statute, are you traveling under 776.012 as your basis for self-defense?
Yes, but this is the problem that I'm having here.
Just so serious. Like, Judge Kraynick knows this. It's not something he just looked up for this particular case. He knows it. And he's trying to figure out, like, do you know what you're arguing? Is this a valid argument you've got here? Or are you just trying to bullshit me? Yeah.
Self-defense is a defense. It's an affirmative defense that's available.
The reason I paused it, though, and recognized that the cameraman zoomed in, he knows something's going on. Cameraman's used the wide shot the whole time. I think he recognized that the judge is like, hold on here. There's a mood shift.
To anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that.
That's 100%. Yes. It has to be evidence at trial. And until that evidence at trial comes out, you're not bringing up this argument.
And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction.
He gives it away right there, too. That's the thing that they needed. It comes up that it's a scintilla. It's almost exactly one scintilla. There's not much more than a scintilla. Some would argue there was only, 2/3 or 3/5 of a scintilla. In any case, there only needs to be a scintilla of evidence that battered spout or that there was an overt act. At this point, they haven't even produced the single scintilla. We'll get to that.
But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion.
So that's because the state already has Dr. Harper's deposition. She can change her mind, but she's going to have to change her mind in trial and explain why she changed her mind. The deposition's been filed, and she didn't say any of this.
Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense.
And that's what happens.
Has to present the evidence of the court talking about that overt act.
Yeah.
It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if...
Well, Mr. Henderson's blowing smoke up Kraynick's ass, I'm blowing smoke up his ass.
Any of that... Excuse me.
He's choking on it.
If any of that presents a scintilla
That's crazy
of
that worked.
To award the self-defense instruction, then the self-defense instruction should be...
Gonna have to do that again. Just, my goodness, incredibly effective.
Excuse me. If any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
It's not incorrect.
Any other argument, sir?
No other argument.
Thank you.
Any other argument, sir? He's not going to argue with them. He's just like, if you're just going to keep telling me what I said is right is wrong.
Self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other argument, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct.
This is
Parties are
procedurally
allowed to
correct.
get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I have cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudice.
Vel 73, I think Mr. Jhaie warms up. I think he's a slow starter. Mr. Cacciatore, we know, does yoga. He keeps himself in shape. I think Mr. Jhaie really needed the power of his socks and ties, and he ramped it up. Just like as the colors got bolder, he got stronger. I think he's just getting his feet wet in this case here. He's showing flashes of what he's going to show us later. But I remember going into it, a lot of us were worried about Mr. Jhaie. A lot of us were like, I don't know if he has what it takes to prosecute Sarah. And yeah, some of his analogies, they didn't quite land, but fortunately he's going against the despicable, truly despicable human who self-snitched and recorded all of her own crimes.
Judicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, could I respond?
Briefly.
Briefly, because I already know what my answer is.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filing, not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes, sir.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now.
Respectfully, it's not, Judge. Look at that face. It's lacking. It's not, Judge.
Turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay, yeah. Bring it the fuck on. Tell us already. What's the overt act? This is funny because they think that having a card up their sleeve is somehow a court strategy.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence.
The state wants to hear our defense.
Because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt act.
So there's their loophole. They're saying we've already mentioned the overt act. We just haven't claimed it's the overt act. It's in the testimony. And that leaves Judge Kraynick at a loss. Like, okay, I've only seen some of the testimony. What the fuck are you talking about? What's the overt act?
I have to tell you, his hand is coming out of the suitcase.
There we go.
That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres' hand that shows a mark on that hand that it matches up with the bat.
Let that sink in. Let that sink in. You know, I'm going to play it for a second before I even say a word. But let that sink in that this is Sarah's defense. 3920. We'll go back 15 seconds. Sarah's defense is...
out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres' hand that shows a mark on that hand that it matches up with the bat.
You'll see there's a picture of George's hand where the damage matches up with the bat. Therefore, my client was facing an overt act. So this is the gymnastics. Basically, the fact that Sarah was even hitting him with the bat is a sign she wouldn't have used the bat if she wasn't in fear for her life. Not because she's an abuser. Abusers wouldn't use bats, you know, just to hurt someone maliciously, intentionally. But no, his claim is that the bat hitting the hand is the proof that she was in fear. Just like Wendy in The Shining with the bat, you know, poking it at Jack Torrance. Sarah was poking the bat at the hand. Well, not even the hand, really, just the two fingers coming through the suitcase, just poking the bat.
That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger.
not like a gun. This is where 100%, this is True Crime Loser said this, but he's like, no, it's not like a gun. If he'd reached out of the suitcase with a gun, yeah, he hit it with a bat. Like, but he didn't have a gun. It's not like he had a gun. It's, you know, there couldn't be anything more different than, you know, than not having a gun. The biggest thing, I think True Crime Loser put it as, the biggest difference from having a gun is not having a gun. Like, that's a huge difference.
It's out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres' hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina.
Is that Chelsey in the courtroom? Chelsey Koepsell there? 4139.
To the second portion, that excluding mention of battered spouse syndrome evidence until.
Yeah, I think that is her.
There's a basis for it. The court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary.
This is just a little ode to agua here.
Predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire, and even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under LAD needs to be established before any expert opines to battered spouse.
My concern is opening. Can it be mentioned in the...
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same.
We have about an hour and a half left of today's hearing. We'll pick this up with a new day of, might be the first day of trial. I don't know if there's some jury selection stuff we can watch too. In any case, we'll be back next Friday morning. There will be no ramble tonight unless it's an unscheduled vertical live, no agenda community chat kind of show. Be doing that for the Watch from World Cup today.
It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Koepsell and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's some state witnesses here. We would like to invoke them.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
Not from the state.
You've got state witnesses here, you know?
She's allowed to be here to watch.
I understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
That's kind of interesting. I don't really remember that exchange before. Let's watch that back a little bit. 440, and I'll give the audio a little bit of gain. We'll pause it again afterwards, but there's a little bit of little tension there. Mr. James Owens is just trying to do the best he can. It's ruining my chance, Your Honor. Okay, a little further back. 44:14. Let's just go to 44 flat. Okay, we'll go from here.
That leaves us to the statements on page 53, line 11.
As soon as he gets quiet,
53,
I'll boost
line
it.
13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
Okay, I think that's where it gets that's where they have a separate discussion. So let me go into settings and give it a manual boost. If you have earphones in, it may be unnaturally loud. It shouldn't be that bad. Just going to give it a 10 decibel boost and see if we can pick up what is being said here.
I believe there's some state witnesses here. We would like.
Okay, so that got picked up. I believe state witnesses are here. We would like. Oh, and I just reversed my audio.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
The rule of sequestration applies to witnesses, not to anything else.
Response?
Is there going to be testimony?
Is there going to be testimony?
Not from the state.
Not from the state.
You've got state witnesses here, you know?
You got you got state witnesses here behind you. So referring to Chelsey and whoever the gentleman is that's accompanied her.
She's allowed to be here to watch. I understand.
She's allowed to be here to watch. I understand. Mr. Cacciatore looking on concerned.
I want to know whether she's going to testify.
I want to know whether she's going to testify.
I said there's no state witnesses.
I said there's no state witnesses.
So that's a no.
All right. I will reduce that super gain, and we'll go back to our regular audio listening. Interesting exchange. That was worth doing. I love the expressions on Mr. J's face. She's allowed to be here. I know. I just want to know.
May proceed with any argument, Mr. Owens. Yes, sir.
Kitten Pusher, there's a chance I'll ramble, but if it happens, it'll just be like a community chat.
I have reviewed the
style
2.8 instruction prior today. Thank you, Counselor.
and it won't be scheduled.
State attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay.
Okay.
Any other argument?
Judge, this was a 2-hour interrogation that
beautiful,
occurred.
too. He's got a tremendous sense of timing. 46:01. We'll go back, 20 seconds?
To my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she had recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours.
They were trying to trick her.
Trying to do that.
2 hours.
Any which way they possibly could. And the law says that there.
Any which way they possibly could. And the law says 2 hours is a totally reasonable interrogation. I'm sure some of us who like the true crime content have watched interrogations that last far beyond 2 hours. 2 hours is a walk in the... And it's funny because Sarah's interrogation seemed long by the 45-minute mark. Like, I love it. I'll rewatch it. But by 45 minutes, you're like, really? There's still an hour and 15 minutes left in this? I think we'll watch it as part of this. I think, yeah, it gets introduced during the trial, so we'll get a chance to watch the video in the context of it being presented in the trial. But yeah, for a 2-hour video, it feels long, but it's not long in comparison to some of the longer interrogations that exist just in YouTube content form.
Are allowed to use, and I cited several cases. I cited the Smith v. State case, the ODEH v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found. Do you need the cite?
I have it. It's included in ODA, but you did not cite it in your motion.
So sharp. You didn't cite that. I know it because I'm not an idiot. Well, I'm not going to imply you are, but you're coming before me citing motions that you didn't cite in the written brief.
Okay.
Okay.
Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime.
That's correct, Mr. Owens. So what are you arguing? I guess it makes sense. You're going to argue against it. First, you straw man the other man's argument or the other team's. But what he just said there is exactly why this is all so silly. Law enforcement's allowed to use trickery to get you to confess. They are allowed to outright lie to you. They can say, hey, we have it all on camera. You're telling us this and we know this, this, and this. They might have some of it on camera and they're trying to test how much of your story lines up with, the evidence that exists. And if your story does line up with all of the physical evidence they have, all of the camera footage, they're more likely to believe the gaps in it when you tell a complete story.
But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit
Sarah Boone
that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter. It may have been.
Good call, Ramono. Sarah cosplaying as a typical Florida Puritan with that silly ruffled collar. Just showed up from Plymouth Rock. Came here as a pilgrim. Got abused by her spouse. That was never a thing back in her day.
Less than that is when
you don't hit
the
a
detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded.
Kitten Pusher, you're not wrong. So this is a third attempt at, another kick at the can, another last bite at the apple, as it were. What James Owens is trying to do now is exclude parts of the interrogation. And one of them is toward the end of the interrogation, and he's successful here. The detective's like, we're saying it because you did it. What do you mean? Why is this happening? Because George is dead. So there's a little bit at the very end that is, he's dead, you did it. And that could be prejudicial to the jury. But it's not going to get the whole thing thrown out. It's just going to have that tiny portion. And I think there's another portion that where Sarah comes off as quite racist, where she's talking about Eli and Kim in the interview. Eli and Kim, Kim and Eli, Eli and Kim, Eli and Kim. Kim automatically, not nice. Automatically not nice. Just Eli, he used to be our friend, but did you know that he might be here illegally? He might not have a green card. So, don't want you to have to leave this interrogation to run over there and throw him out of his house. But whatever you got from Kim and Eli, that's not going to stand up in court. Anyway, that part got cut out of the interrogation too, but that's what's happening here, Kitten Pusher.
53, line 11.
Sarah
Well,
Boone.
he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions.
That's it.
She responded,
he's dead as a result of your actions. So, yeah, it's an opinion. It's an informed opinion because they just finished their investigation. But this is the part that he is going to be successful in having excluded from the trial evidence.
line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about.
No, they're not.
The probative value of that type of opinion testimony about...
And again, so that's a decent argument. He's going to get this tiny slice. The pie is staying. The whole pie will be there, but there's a couple of bites of the pie that he's like scooping out, tiny bit of mold on this, but the rest of the pie is fine. Little excising, but it's strategic, and we know it's not going to have any effect on the case.
Her guilt is outweighed by the prejudicial effect.
Amy Z.
Thank you.
Liking the new name.
The state stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. Jhaie. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you.
So just not a full stipulation, but basically, and it's correct. What he's saying happened in the video did happen. That's a fairly accurate portrayal of the transcript.
You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement.
And was everything you told us true and accurate to the best of your knowledge? What, that it wasn't intentional?
He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview.
Exactly. It's just he's expressing his personal disgust with her.
So we defer to whatever the court's ruling is.
Okay, thank you.
She's despicable.
Just for the state attorney not to put that in there, the italicized portion, where Supreme Court is giving instructions to the court with those comments, for them not to put that in there, I disagree with.
For them not to put that in there, I disagree with.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have, and I do find that this is expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from.
So
I apologize.
the win.
Thank you. The defense's motion is granted.
Oh my, I'm a winner. I can't believe I won. That's exactly, oh my God. Me? You really, really like me, Judge Kraynick? I think I have a chance. Oh, I'm definitely rejecting any plea offer now.
For those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regard to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Okay, this is an argument. I guess Sarah wants to bring in George's medical records as part of her testimony, and state is going to argue for why that shouldn't be the case. And I believe state wins this argument.
Judge, just the other night, I received 550
See you
pages
soon,
of medical
Margarita. Thank
records
you for spending time.
regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I had not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes. And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive, and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant to what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the court right now.
That. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres' medical records prior to me sending them to you?
Did y'all not have? Just turns from addressing the court to addressing the prosecutor or the state.
All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be...
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony...
You are the proponent of the evidence. Yes. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40-some-odd pages I think the state identified as that, what of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well, the state's position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a .31 BAC. Every time...
In 2018?
2018?
I'm talking about the 2018 incident with regard to the plate glass window.
I have to look at the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a .3. When he gets over a .2 to .3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know,
Nothing.
it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
That's not how motions in limine work.
It's not a thing.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't.
So blood alcohol concentration, or the narrative basically, you know, if there's a hospital visit, why were they at the hospital visit?
Know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
Okay.
Response.
He's very, you know, he seems like a poker player the way that he holds his emotions in, Judge Kraynick. Oh, I love that Sarah's surrounded by all the snacks she can't eat on this freeze frame. Yeah, he seems like a poker player, and at the same time, you can tell when he's like, I've decided, you can keep talking, but that's your argument? Okay. Anything else from a legal perspective?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is
Okay, third day of jury selection. That's a good timestamp for where we are in the trial. Very close to the beginning.
wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021.
Exactly. James Owens isn't on trial. It's not like he just got provided with his defense 2 weeks in. He swooped in, voluntarily said, hey, if the public sector's not going to help out a client, the private sector has to swoop in and, we have to do what we can to help out. I'm just doing the best I can, my honor.
And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Miss Boone's box, apparently, that Billy Lane had acquired years ago. So
they were sitting in Miss Boone's box. That's, I'm sorry, we're going to have to listen to that again.
I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Miss Boone's box, apparently, that Billy Lane had acquired years ago. So
they were sitting there in Miss Boone's box that Billy Lane had acquired years ago. Ugh. Sounds like how you get an infection. Disgusting. One more time.
21. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Miss Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident. I find potential relevance, so I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds.
She thinks she has something. She thinks she has a card up her sleeve.
These other documents relevant. Because at this
Yeah, stream's not frozen. I'm just taken aback. You know, for someone who doesn't listen most of the time, she heard something there she really liked.
At this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right? Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right, thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And
hey, what's up, Margie?
this is why my
Margie 420 has
paragraphs
entered the
start with
chat.
0 in my response because they have a paragraph 1A and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 20th,
Mr. Cacciatore, you're getting a little tired of all this. And to be fair, Mr. Cacciatore's been with this case from the beginning. Mr. Jhaie's the one coming on for trial. Just have a little look at Mr. Cacciatore here.
For each item, tracking their fifth amended exhibit list.
but here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
That might be a them problem. We've got about an hour and 20 minutes of raw footage left in this stream. I'm also up against a hard deadline of 3 p.m. Pacific time. 3 for the Canada-Bosnia-Herzegovina football match in the World Cup. Going to see, hopefully, Canada win their first World Cup game in World Cup history. They've made it to the show, but never won a game yet. A few draws. They've had some scrappy teams, but anyway. So, yeah, there's, what is it now? Yeah, there's not going to be 2 hours in the stream, but there's definitely not going to be more than 2 hours of the stream. I'm going to try and keep it to about an hour and a half based off of the hour and 20 minutes we have remaining.
Getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left, so I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's
It's a
not
them
filed
problem.
with the clerk of the court to the defense.
Okay, all right. I need clarification, Mr. Owens, as to when the Fifth Amended
Herzegovina. Bosnia-Herzegovina is going to be the team that gets to avenge my horrible pronunciation of their country's name.
reciprocal discovery exhibit list was filed, and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
Oh my God! I have a body cam video where the woman says "cocksucker" with such an AH, like, and so many times. We'll hold it for the future. There's nothing timely. There's nothing relevant. That's just a back pocket cocksucker video that we've got of a woman not happy with her arrest and doesn't believe the police understand the laws of custody. You cocksuckers.
You're asking for when it was filed? We're checking on that. When it was filed, what was the
Thank you,
next
Vil.
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third.
Phil for Dom Russo. We don't know who that is, and there's a third person back there. He's kind of got his head in his hands. Oh, he's lost in the peppermints in my feed, but yeah, it could just be a companion. It could be Chelsey's current partner. This is, remember, 4 years down the road, so Chelsey's now a lead detective, and very well might be her junior partner accompanying her, just to get a view of how cases go full circle. And, you know, when I was a junior detective like you, I took the lead on one particular case, and it took 4 years to get through the system. Come with me, and you'll see what happens when you have to testify in your own cases. That's my speculation.
Amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your Jhaie?
Or you can send it to
What?
Madam Clerk and
The
she can
game's
print
on?
it out to me, because I'm having
Did I get
difficulty
Eastern time
lining
wrong?
up what these things are, because all I have in the court file is
Motherfuck, I do
this was
this all
sent
the
on this
time.
day, but I don't know what any of these things are.
We can move on.
The game better not fuck me on.
Unless we've got some housekeeping matters to address.
I thought it
for this
started at 3.
afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second.
Motherfuck me, it better not be on. I planned my time so poorly.
All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel.
No
No, I'm
fucking
sorry.
way.
Juror number 471, panel 3.
What have I gotten
seat
wrong?
48.
It started 23 minutes
Tested
ago?
positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure.
Okay, I'm
Juror
going to be
number
watching the Bosnia game
471,
in the
panel 3.
side
That would have been
window.
yesterday morning.
What?
Seat 48.
Excuse me. Oh my God. Oh, I'm such a bad planner.
Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around.
The corner kick past Maxime
The
Crepeau to open the
other
scoring.
juror 551, I don't
Oh,
have any other
no.
information as to what panel
Canada's down.
or seat. She took a COVID test and was negative.
Halftime.
She is planning on reporting today. So due to the shrinking
from 54 to 53. Jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So, are there any housekeeping matters to address from the state before we address the objections issues?
We've had 8 corner
Wise to
kicks.
not utilize that expanded space when 2 of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor.
Oh,
Would
interesting.
it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
I don't know if they change courtrooms.
Response.
I think he stays here.
Can you all approach just for a second?
Okay. We may need to pivot. I may need to end the stream. We'll do the same thing. We'll do a halfway. Where are we here? We're at 1 hour and 20 minutes. The stream itself is another hour and 10 minutes long. There's a boost of interest by 147. No, halftime will be over. Oh, yeah, I've planned poorly. Well, that said, I wasn't getting up any earlier than 8:30. I just should have made a plan to not continue streaming into the World Cup starting. Dumb. Okay. Not as dumb as Sarah, though. It's one of the saving graces of covering Sarah is no matter how dumb you are in your life, you can take solace in the fact that not as dumb as her. Okay, let's watch this on some speed until they're talking. Probably make her more interesting to look at as well. Yeah, soccer's the one game that I played for most of my life. I only gave up last year. I was playing indoor soccer as a goalie for a indoor soccer team. Men's team. It was.
We're going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the Fifth Amendment exhibit list. With regard to Juror 551, what say the state?
No objection. Well, if he doesn't have COVID, then I have much cause.
Okay. Any response from the defense?
Okay, they've agreed to a 15-minute recess.
Correct. That is correct.
I think I'm going to take a 15-minute recess till next week. I think what I'll do is I see there's a huge peak here. We'll preview what we're going to look at next week. I'm going to go to what I think is the most viewed part of this video, and it happens right around the minute or hour and 53 mark, and we'll come back to the hour and 20-minute mark to watch. But yeah, as a reward to you guys for my poor planning, we will go to the best part of this video to end this video, and then we will be able to rewatch it when we come back next Friday. Really? That's the beginning of the best scene? Okay. Must be that they're coming back to court. Oh, there's a huge gap where there's nothing. We just skipped past Sarah shuffling papers. We'll come back for it. I'm all about Sarah shuffling papers, but that's good to know. There's a huge section of nothing. And the reason this is the most replayed isn't because it's necessarily good. It's just people realizing that the show's starting again. Still, we'll watch it.
All right, we're back on the record, 2020 CF.
We'll give it 5 more minutes.
2603, State of Florida versus Sarah Boone. State, you can get appearances.
William Jhaie for the state.
Defense. All right, thank you.
What a winning
Ms. Boone
smile.
is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's Fifth Amended Reciprocal Discovery Exhibit List. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's Fifth
Get to the mic. Speak into the
Correct.
mic, Mr. Owens.
But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir.
Judge, I'm going to handle this.
Okay, go ahead.
And Judge, this was a little bit of a
Little Mr. Henderson,
new
okay.
procedure because what I did was review the images and these, as in the motion.
Oh, this is
we
terrible.
object to all the cell phone
You know what?
photo evidence. The state intends
Oh
to
my God.
introduce a trial.
If I didn't end it early, we would have dropped off all of our viewers within about 10 minutes of this. This is the kind of energy we can start a stream with, where I can carry it with my own. But we can't watch. Yeah, look at the peak just drops. Everyone's like, oh, Mr. Henderson. And then there's a little bit when Sarah comes back. Yeah, we're not missing nothing here. We're going to this screen, and I will launch my video in the back screen. I think that's that one. Is it playing? I don't think it is. Refresh. Maybe it's played too often. There we go. Okay. Yeah, I planned poorly. I gonna go watch some football. Yeah, maybe it'd be lucky. Maybe I didn't want to see them get scored against in the beginning, but now I'll go watch and it'll be fantastic. USA is playing Paraguay. I know that's happening after. It's probably happening sooner after. The other thing that I'm gonna do is possibly, if I do a ramble tonight, it'll be an unscripted community chat, possibly a vertical chat without any video, maybe kind of this screen that we're doing right now. And my thought is Tam Namasti mentioned interest in just a community chat about how to start your own channel, how to make your own videos, how to go about. So anyway, if there's any questions, you've thought about starting your own channel, you have started your own channel and you're trying to grow it, you're just even a little bit interested about making videos, any of that kind of stuff, if I'm online tonight, I'm prepared to talk about it. I might even prepare something to talk about. And if you don't, you just want to talk about something else, by all means join, because I don't know that there's a ton of people that are wanting to create. So, yeah, I'm going to head up. I'm going to go watch the game and enjoy my company, enjoy my country's company, and wish them luck through the second half. I hope everyone is having a fine and dandy day. You're all fine. I'm dandy. Oh, the finger. Okay, yeah, there. Just kind of pretend like that's the look out the window. I'm dandy. You're fine. Together, we're fine and dandy. My mom thinks it's hilarious. She now tells people, you know how Taylor Swift has Swifties? My son has dandies. 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 Know that. Yeah, so I love the dandies. Thank you for spending your time with me today. We will revisit this video, and we're that close to the snacks motion and the start of the trial. The snacks motion is the last thing before the trial. So as soon as the snacks get delegated or denied, stay tuned. We'll get into the trial. And then the trial, it's 5 days of video, but we're not going to do the 8-hour long streams. We'll just take chunks of it. Maybe we'll take, 2 witnesses from a day, or 2 hours of video from a day that I'll turn into 4.5 by the time I shut up. But yeah, that's the plan. That's how we'll go forward. No scheduled ramble tonight, but maybe an unscheduled one. And other than that, I'll see you next week. Stay tuned. Shout out to Danielle Chavon. Sunday Fun Day next on your Sarah Boone calendar. And yeah, maybe I'll go up and make meatloaf for Mom. That'll put a twist on it, right? Hey, Mom, meatloaf. I don't know what she eats up there. All right, that's it. cutting it off. That said, I'm going to... Oh, no, Johnny Somali. I want to do a update on him. Tosi did an update. And yeah, there's some new developments. He's fun to watch too. We've got a backlog of stuff to do. But we'll catch up. We're going to have a good time. Thank you so much. And everyone have a great weekend. I'll see you in the other chats. And this is my fine and dandy countdown. 10, 9, 8, 7, 6, 5, 4. Juror number 3 said yes. 2, 1. Fine and dandy, goodbye.